Hello, my name is Sandy Hawkins, and this is HCA 322, taught by Professor Joanne Poe, Week 2, Discussion 2, Courtroom Drama. I am making this video to argue my decision for either the plaintiff or the defendant in the matter of case number 3, Public Hospital Corrects Impermissible Disclosure of PHI in response to a subpoena. The issue is whether there were impermissible uses and disclosures of a patient's protected health information, PHI, the plaintiff, Jennifer, and from the hospital, the defendant. I'll be reviewing arguments from both the plaintiff and the defendant in this case, and then I will make a decision to rule in favor of either the plaintiff or the defendant. The plaintiff, Jennifer, is suing AU Hospital, a general hospital, for impermissible uses and disclosures of her protected health information. The defendant, AU Hospital, is defending their organization, stating that they did not wrongfully disclose any of her PHI. First argument I reviewed was the plaintiff, Jennifer. She is claiming that AU Hospital disclosed her PHI in response to a subpoena. She argues that her privacy was violated because she claims AU Hospital failed to verify that the party seeking her PHI made reasonable efforts to contact her and notify her of the requests. They also did not have a court order. She argues there was a breach of confidentiality because AU Hospital disclosed her PHI to another party without her consent or knowledge, nor did they make reasonable efforts. Jennifer argues her privacy was violated because she was not in control of her PHI, nor was she notified of their request. Now, the second argument I reviewed was the defendant, AU Hospital. The representative for AU Hospital is defending that the hospital took out any identifiable information of the patient on the documents that were disclosed to the other party. This process is called de-identification. According to the Department of Health and Human Services, the Health Insurance Portability and Accountability Acts, or HIPAA, the privacy rule provides the standard for de-identification of protected health information. De-identification is a process where 18 specific identifiers are removed from a patient's records, such as names, dates, phone numbers, social security numbers, or medical records. If all 18 identifiers are removed from the patient's file, it no longer has any definable qualities that are a direct link to Jennifer, so they no longer are obligated to notify Jennifer. According to HIPAA, there was no breach of PHI because they removed all 18 identifiers. Once de-identifiers is implemented, the privacy rule does not apply because it is considered or does not apply because it does not restrict the use or disclosure of de-identified health information, and it is no longer considered protective health information. Under HIPAA, the privacy rule is no longer applicable if impermissible uses and disclosures of a patient's protected health information is violated. The rule permits covered entities to disclose protected health information to law enforcement officials without the individual's written authorization under specific circumstances, such as to comply with a court order or court-ordered warrant, a subpoena or summons issued by a judicial officer, or a grand jury subpoena. HIPAA 445 CFR 164.512 F1 2A through B, Section F, states a covered entity may disclose protected health information for law enforcement purpose to a law enforcement official if specific conditions are met, a court order or court-ordered warrant, or a subpoena or summons issued by a judicial officer. Therefore, I find in favor of the defendant because AU did not have to notify the plaintiff as they were served a subpoena. Thank you.